ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
Mom, what did the man mean when he said go back to where you came from?
Go back, wherever you're from.
Why do they make fun of my name at school? Dad, who will protect us from climate change?
Global warming, and that a lot of it's a hoax. It's a hoax.
When is Mommy coming back from hospital?
Our family's future is at stake. The choice is ours. Vote Asaf and Warnock.
I'm a lifelong Republican and I'm pro-business.
I'm a Georgian and I believe in personal responsibility.
I'm a Georgian and I rely on my Social Security and Medicare.
I am a mother and I believe in immigration policies that support family unity.
My party is not fiscally responsible anymore.
It's irresponsibility that's costing us our lives.
It threatens my Social Security and Medicare.
It is keeping our families apart.
That's why
I am
I am
voting Asaf and Warnock.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా.
TVASIA Telugu ప్రేక్షకులందరికీ hello and welcome back to yet another fantastic episode of the talk show with the experts. మనతో ఉన్నారు మన expert Rahul Reddy garu from Reddy Neumann P.C. Rahul garu, thank you so much for being on the show today.
Thank you for inviting, and it's always a pleasure to be there every Sunday to be with మన శ్రోతలతోటి మాట్లాడి. It's a very entertaining thing every week and I look forward for it.
Oh, thank you so much. And I'm sure our viewers are also waiting. Our callers are waiting. I can see that. So without any further ado, let's get started. And so ఈసారి ఇంకొక ధమాకేదార్ టాపిక్ అన్నమాట. The Senate passes the bill to remove per country limit. Now this is big news. Ade, what does this mean for us, and would it impact the priority date? When would it move? Koncha dan gurinchi, can you elaborate, please?
This is the end of all the problems we have.
Okay.
End of all the problems. What problems we have? Number one problem is green card was taking 100 years. I mean, technically it was moving every 10 years. It was only moving 1 month or 3 months forward. So that problem will be solved forever. Okay. Second problem, H-1B extensions. Do we actually need H-1B extension? A close reading of the bill requires that maybe we don't need H-1B extensions at all. H-4EAD delays. We don't need to worry about H-4EAD delays. Lot of problems. I mean, there are age-out kids. The children who come in as a dependent on H-4, they're becoming 21. That's been resolved too. We have been fighting for this since the time I was trying to get immigration.
Wow.
I got immigration, I got green card in 1996. I got in May of 1996. In June, the visa dates backlogged. From 1996 onwards to right now, we are facing the discrimination. Previously, we didn't have that much rush. It was okay.
Right.
So everything is backlogged from 1996. That's when I got my green card in May. And now it's backlogged. And it's not, the pain is not just the backlog. The way the law treats the individuals is that you guys are worst guys, worst creatures in this world. And that happens to be Indians according to the law. So if you're born in Pakistan, Bangladesh, if you're born in Nepal, if you're born in Japan, if you're born in England, if you're born in Canada, if you're born in UAE, if you're born in any other country other than India, you're good. But if you're born in India, you have been discriminated. Unfortunately, the discrimination, non-discrimination laws that are there in the Constitution, the provisions are not applicable to immigration. So we have been discriminated for so long in this law. This law may not completely eliminate the discrimination, but to a great extent, it brings down the discrimination. In a span of 10 years, it will clear the entire discrimination. So when we were getting green cards, for example, we have been limited only 7% out of the 140,000 employment-based green cards to be given to us. What they are doing right now is they are lifting that gradually. Okay. For now, we can get up to 75%, and later on it goes to even more percentage. So it will eventually eliminate the discrimination. So from 10,000 green cards every year, we may be getting between 80,000 to 110,000 green cards every year.
That is amazing.
Yes, that is amazing. So we have seen, Nitya Garu, that the dates have moved. Dates have moved because we got extra 100,000 green cards for family immigration to the business immigration, mostly because there is not much competition there Indians are getting. Imagine that going forward every year. That's one good news. The other good news is that it's not just the priority date. If you have an I-140 approval for more than 2 years, and you're still working with the same company, even if the priority date does not become current, even if it does not become current, we can file the adjustment of status and EAD for the wife and husband. There's a little bit caveat, the children may not get an EAD. I will take it, I'm fine with it. Okay. So this provision allows everybody who's getting I-140. Now, all this good news, I mean, I have never had so much joy as much I had when it's Senate 386 bill passed. Absolutely is the best thing that can happen. Now, a lot of people are joying, oh, this is favoring Indians. No, it's not favoring Indians. It's just making everybody the same thing. It's treating everybody the same way. They're not discriminating. If you take up the discrimination, doesn't mean that Indians are favored. It's just that, you know, it happens to be the number of people who are waiting are Indians, so we're getting the benefit here. So this is the best thing that could happen. But one twist that everybody who's listening to this and who have heard all this good news, we have had a bill passed in the House of Representatives. Well, in India, you call this kind of thing as Lok Sabha, and we have had this bill passed in the Senate. The only thing is there's a little bit difference between the bill, between the House and the Senate. There are some technical things that need to be worked out between the committee. I'm expecting that to be done, but I want everybody to be on their toes. And I'm going to draft a letter on Monday and put it on my website, rnlawgroup.com. I'll also put a link at the bottom of this YouTube that we're having. I want people to get there and write the letter to the congressman to have this bill succeeded so that everything gets done. We are in the best shape. We don't need any other thing. This is the best thing that happened to us.
Right. Oh, that's amazing. I'm sure it's a relief for a lot of people who've been waiting for
Of course,
together,
it's a lot of relief. Yeah.
Yeah.
I didn't waited in 1996 to get the green card, but everybody who got the green card after 1 month of me, they had to go through torture from 1996 to 24 years. Is it 24? Yeah, it is more than 24 years. Yeah. It was a torture for all these people. That will be eliminated once this goes through. It's a technical, but everything has to be done before December 18th. It cannot be done after December 18th. Why December 18th is because the House is not scheduled to meet any time after December 18th.
Okay.
We call this session as lame duck session.
Okay.
On January 20th, the new Congress, the Senate and the House is going to come into power. So this old Congress, even though they were being voted out, they are in power until January 20th. So this lame duck session for the House is ending on December 18th unless it's been extended. So since the House hasn't changed much, they may not extend it beyond December 18th because Nancy Pelosi is still going to be power in January 20th. So they may not be extending. So I want everybody to be on the toes, request them. The HR bill is called as HR 10044. When they're contacting the House members, you need to contact with the reference to 10044. We're going to put that link by tomorrow on this YouTube channel, YouTube of TVASIA.
Okay, great. Fantastic news, Rahul Garu. This is, I think, on so many levels, it makes a lot of things easier, and people have less sleepless nights and matter. So on that note, let's start taking our callers one by one. So let's go on to our first caller, sir. Area code 425. Hello, sir. Area code 425. We're on right now. Okay. In the meantime, let's take one of our YouTube questions. This is from Sridevi Srinivas. She says, Rahul sir, my priority date is March 2011 EB2, and attorney filed my 485 on October 20th in Chicago by mistake. He made stop payment on the first 485 and filed a new 485 in Phoenix on November 20th with a new check. Is this fine?
That's fine. I mean, he filed within time right now with a new address, so you're in good shape. I'm not sure if I would have done the stop payment. It may backfire on it, but as such, they may come and collect the money. I don't care about it if I were you, but he filed a new application, so you're in safe right now.
Gotcha. Okay. Awesome. Let's try a caller again. Hello?
Hello?
Hello, sir.
Yes.
Yeah, we hear.
Sir, very good afternoon, sir. Sir, Narendra here from Seattle. Sir, I have two questions. Sir,
Yes,
actually,
sir.
My company... Hello?
Yeah, go ahead, Narendra.
Sir, actually, my company applied for work permit, Canada work permit. So what happened, that got approved, but unfortunately, because of COVID, that location got, they have cancelled, they moved to some other location.
Did you say Canadian work permit?
Yes, sir, Canadian work permit, yeah.
I don't know anything about Canada. This is just a U.S. immigration.
Okay.
I have no clue about Canada. Sorry about that, Narendra.
Okay. Okay, sir. So that's fine, sir. One more question, sir. Following question. Actually, suppose PERMO, still I'm waiting for PERMO approval, and suppose it's delayed out of our H1B 6-year duration. So how many days before can I leave from the country, sir?
How many days before? I would recommend at least
max out dates. 10 days.
10 days would be ideal for you.
Sir. Okay, sir.
Thank you, Narendra.
Thank you, sir.
Sorry, I couldn't answer anything about Canada.
Thanks a lot, sir. Thank you, sir. Thanks a lot, sir. Thanks for your time.
All right. While we take our next caller, Rahul Garu, let's go on to our next YouTube question as well. This is from Michael Williams. He says, amended EB2 to EB3 and also did successor of interest. Company got merged to parent. Can I change job using H1B transfer in less than 180 days of the 485 receipt, or do I have to wait for at least 6 months? And if I change the company after the 180 days using an H1B transfer, does the new company need to start processing again?
First thing is that I don't want you to make any move whatsoever at all until your I-140 with your company has been approved. There are two things here. One is the downgrade application. The other thing is that there is an amendment in the application. I would want you to do the premium processing. Sometimes they may not allow the premium processing. Most of the time recently, we haven't had any failure. So you do the premium processing of the I-140 application once you get the receipt notice. That's number one. I also recommend that you don't make any move whatsoever at all until after 180 days since the I-140 has been approved. This is not a very strict rule, but I strongly recommend. Now, I am assuming that you will make a move after the I-140 has been approved and after 180 days after the I-140 is approved, yeah, you can move to a different company. When you move to a different company, you have two options. One is H-1B and 485J supplement. You don't have to file a labor and I-140 again if you follow my directions. But if you don't follow my directions, then you may have to file everything back again, labor, I-140 and adjustment of status again. But if you follow, you only need to do, you can do H1 and 485J supplement. These are the two steps that you need to do. Now, it is optional that if you follow my directions to do H1B. It is up to you whether you want to continue maintaining H1B or not. A lot of people may not need to continue H1B, especially after the I-140 is approved and it's more than 180 days, it's been passed and you don't have any, black marks on your entire thing. I'm not sure if it's needed for you to continue the H1B. A lot of people, we discourage people saying that, yeah, don't get married to the application, but if everything is good, I mean, everything is I-140, underlying I-140 is approved, and it's been more than 180 days. Right. You can kiss goodbye to H1B. You don't need to carry both burdens. You can say goodbye to the AB3. Goodbye to H1B. I personally, if I were to have to maintain both the things, if my I-140, my adjustment of status is clear, I'm going to kick goodbye to the H1B.
Right. And that's kind of what I did also when I was in the similar position. So the
I mean, why feed the immigration lawyers so much? Do you have so much love to feed them? I don't love immigration lawyers. Though I am one of it, I don't love them. I used to be an immigration client before I became an immigration lawyer. Right. I don't love them. I just use them, got my work, and then that's it. I don't want to be with them for a long period of time.
Right.
Unfortunately, you have to, as a host.
True. Yeah. All right, on to our next caller then. Hello, sir, area code 973. We're ready for you. Hello, sir. *6 press cheste unmute chesukochu. So please press *6 to unmute your call. There you go. Hello.
Rahul Garu?
Yes, sir.
Hello, sir. Thanks for all the things you have been doing for this community. I really appreciate it. I do have two questions, sir. I'm EB2 category India, and my priority date is October 2009. So I'm expecting my priority date to be current, anytime, next month, hopefully. Mm-hmm. I filed for my 485 in 2012. After 1 year of filing, I changed to a different company. After changing to a different company, I filed for AC21 at that time. During that time, there was no obligation of 485J and all those things. Till now, I haven't filed for 485J.
There was no form called 485J at that time.
Right. So at this time, when my priority date becomes current, will I have any problems? Because I filed for my AC21 portability at that time itself and informed.
Did you get recently any RFE for you?
No, I haven't gotten any RFEs on my 485 till date.
Right. They will not give a green card to you unless they issue an RFE for you. There are two options that you have. What I normally tell people is that assume that you get an RFE, respond to them. There are three questions they normally ask in the RFP. One is medical, because medicals expire in 2 years. Since you submitted the medicals in 2012, it expired, we know that, and you haven't submitted anything. So they cannot legally give you the green card. So what I tell people is that assume you get the green card, RFE, and send them three things. One is medical. The second thing they ask is G325. They're asking the employment history and your address history in the past 3 years. I will submit the G325. The third and the most important thing they normally issue in the RFE is, are you working with the same company that filed an I-140? If so, we want them to sign a 485J supplement. If not, we still want the new company to file a 485J supplement. These three things, you can just assume it. You can work with your immigration lawyer and respond to the RFE. Respond as if there is an RFE. The reason is that when the priority date becomes current, you know what your immigration lawyer is doing? Not your immigration lawyer. Your immigration lawyer is working on Saturdays, Sundays. But what is your immigration officer doing? He's sleeping. He's sleeping on your file. You're coming very close to the priority date. He should have been issuing an RFE. What is he doing? He's sleeping. He doesn't know. The system doesn't tell him, oh, wake up, wake up, wake up. It doesn't tell. So what did he just do? He just slept. When the priority date becomes current, then it tells him, wake up, wake up, wake up. Then what? He wakes up. And there are so many calls getting, wake up, wake up, wake up. Which one he's going to pick? He may pick yours. He may pick somebody else to issue in a line of RFE. So what I do is that I call it as an interfiling, and I respond to the RFE as if there is an RFE. And then guess what? Your guy is sleeping there. All of a sudden, he gets an interfiling with all RFEs there. Why is this guy sending? Then he makes a note of all these things. G325, take. 485J supplement, take. Medical, take. Okay, this guy is ready for the next 2 years. So if it becomes current in the next 2 years, I can approve this guy. So that's a way to wake this immigration officer up. Or you can wait. But my recommendation is don't wait for that guy to wake up. You wake him up.
Okay, sir. Thank you so much. And while filing for 485J supplement, do I need anything from a prior employer at this time, like related to my I-140 petition?
You don't need an I-140 petition as such, but if you have a job description from the previous company, it's going to definitely help your the lawyer who is going to wake this immigration officer up. It's going to definitely, just the job description itself is enough. Nothing else more is needed.
Yes, my attorney got it from 𝗧𝗔𝗟𝗞 when I filed for my AC-21 itself. So
yeah, that's enough.
That's
enough. Then that's enough. Yeah, just that's more than enough for them to submit a 485J supplement. Rest medical and G325 doesn't need anything from your previous employer. Okay. Thank you very much for tuning in.
One more thing.
Yeah, go ahead.
One more thing, sir. So my company is big financial firms, and they don't sign the forms and all those things. Like when you work with big financial firms, like how have you had any experience there? How they file this 485 supplement and all those things?
They were not filing that much. Right now, they're very familiar with the 485J supplement. I was shocked. I mean, recently they have done very good in the 485J supplement. Right now, they're very familiar because it's a big financial firm. Their law firm must be either Fragaman or Barry Appleman. You don't have to name it. So they're very familiar with it, the 485J supplement.
Okay. Thank you, sir. Thanks for all the answers.
Yeah.
Awesome. So while we take our next caller, Rahul Garu, we have a question on YouTube. This is from 𝗧𝗔𝗟𝗞 𝗦𝗪. It says, Rahul sir, please help understand why the H4 application I-539's dates are going forward and backward during the recent times, especially when there's no, I guess, movement in the priority dates, like in GC connected with this.
Well, I am a lawyer in India. I'm a lawyer in United States. I did not work that much as a lawyer in India, also none at all. One thing which is very common between the bureaucrats in India and the bureaucrats here is that what all they do is that they sleep a lot on the files. I mean, absolutely there is no bribe at all. I've never seen it at all, not even heard about it in the United States, nothing at all. But this part of it is very common.
Okay.
So right now, there is an excuse, COVID, oh, COVID. By the way, these officers were never working in the office, immigration office. COVID has nothing to do with it. You could take your files, you were taking the files to home and working. What does COVID has to do? You're working at home. Previously, you can go to ballpark, you can go to bar, you can go, right now everything is closed. You can't do anything. You just need to work. But you know how the government officers are, so they're sleeping right now. So that's the reason you can see the H4 EAD delay in California Service Center, Nitya Garu. You won't believe it, how much time they put on the website. 20 months. 20 months. That's the time that it's taking though. So unless you join the court litigation that we do every other month, there is no hope. I mean, you can try Ombudsman, that's online. You can go Ombudsman USCIS. You can contact the congressman and senator. That doesn't do anything. This is, the third thing that you could do is that you can raise a service request. You can request why you need this EAD emergency. You can try all these things. If that doesn't work, you may have to look into the court system to go and try to litigate this matter. But otherwise, it's taking that much time. It has nothing to do with the adjustment of status, guys. Nothing to do. Adjustment of status came in only in October. Remember, before October of 2020, there was nothing like the adjustment of status. A lot of filings of adjustment of status was not there. So it has nothing to do with the adjustment of status, just the natural delay. But it's also caused by the administration intentionally harassing the immigrants. How did they wanted to delay these applications? They don't want EADs. They don't want people to work and pay money to the taxes. I don't know why, but they don't like immigrants. The current administration I'm speaking about. So they instituted a thing called biometrics. That is a humongous bureaucratic process for every 539 to get this biometric process. They didn't release the information. How many terrorists have you found in this biometrics? You are taking fingerprints and biometrics with a 4-year-old kid. How many terrorists they found? As of now, according to official information, 0. They haven't found. Why did you do all these things? Just to harass it. So there are other procedures that put the I-539 column has been changed, public charge and other things only to delay. And unfortunately, not much can be done other than going to the court system.
I guess so, yeah. Fight the system.
Yeah.
All right, Rahul Garu, time to go on to our next caller. Hello, sir. 515 area code.
Hello, sir.
Hi.
నా క్వశ్చన్ వచ్చేసి నేను ఓపెన్ వర్క్ పర్మిట్ అంటే వైఫ్ డిపెండెంట్ మీద కెనడా వచ్చాను సార్ 2 months బ్యాక్. నా ప్రయారిటీ డేట్ వచ్చి April 2018. నేను ఇంకా US లో జాబ్ వదలలేదు. నాకు ఇంకొక 1 year ఎక్స్టెండ్ చేశారు 2021 వరకు. సో లుకింగ్ ఎట్ దిస్ 1044 bill, do I need to make plans to come back to USA?
If I were you, I would. One catch to this law is there is a different interpretations by different people, though. According to my interpretation, it is becoming effective on October 1st of 2021. According to my business partner's interpretation, it may be becoming effective in 2022. But either way, it's only becoming effective, even if you take the liberal view of mine, it's becoming effective in October of 2021.
Okay, sir. Thank you. Thanks for your
So we have to look into the details. The 180-day rule that we were speaking about, I was answering questions to other people. We don't know whether that is applicable to you or not once you file an adjustment of status. That seems to be good news, though. So when the regulations are going to come out on this, how to interpret this law, we would be able to get a clear thing on how it's going to be done. So I will be on the toes, and I will advocate you to write a letter to the congressman to pass this do these amendments, and then be on the alert and probably plan myself to be here in the United States, because I know the reason why you went to Canada. You know why? Because you couldn't get the green card here. Correct me if I'm wrong. So that's the reason why you may be better off coming back, and that's the reason since this law is very good for you, I want you to be alert on it, keep the job, and try to see if you can come back, okay? Thank you very much for coming in.
Yeah. One last question, sir. నాకేమన్నా ప్రాబ్లమ్స్ ఉంటాయి సార్. ఐ మీన్ ఇప్పుడు నేను సేమ్ ఎంప్లాయర్ సేమ్ క్లయింట్ తో వర్క్ చేస్తున్నా, నాకు అప్రూవల్ ఉంది 2023 వరకు H1 అప్రూవల్. ఇఫ్ ఐ గో ఫర్ స్టాంపింగ్, will I get any questions? What were you doing there, like any days నుంచి?
They may always question that, and you can say that, I'm spending time with my lovely wife because of the COVID situation, nothing wrong with it. Make sure that the documentation is very clear, that you have the job, you're getting paid, the end client letter is still supporting you, that you are working there. If you have these 3 things, you spending time with your wife, nothing wrong with it. The main question that they have is, do you still have the job in the United States? And these 3 things will prove that you still have a job in the United States. So you should be able to come back.
Okay.
And make sure, even if your wife meets or not, get her an H4 visa, okay?
Yep. Thank you. Thank you, sir.
Thank you very much.
Great suggestion, Rahul Garu. Thank you, sir. Thank you for calling. All right, while we take our next caller, Rahul Garu, we have a question on YouTube. This is from Arun. He says, I filed a 485 with my old employer, but I'm working on H-1B for company B. Should I file supplement J after 180 days with company B, even if I'm not married to this 485? Also, if my new employer files a new labor and I-140, can my new employer interlink the I-140 to my 485 filed by my old employer?
First thing is that he has to file a 485 if he does not intend to go back to the company A though. He must file a 485J supplement with company B, irrespective of.
Okay.
Supplementing the supplementing the I-140 with a new employer may or may not do that good, because once you do the 485J supplement, practically all the sponsorship has moved to company B.
B. Okay.
Yeah.
All right. Okay. So Arun, I hope this helps you. All right, let's go on to our next caller. Sir, area code 773. We're ready for you. Hello, sir. Please press *6 to unmute your line. Sir, please.
Hi, Nitya garu.
Cheppan, sir. Here. Hi, Arun.
Hi, Rahul garu. Currently, I'm working on H-1B. And my job title is project manager. If I get promoted to supervisor and job responsibilities will be almost similar, does my company need to do H-1B amendment?
Well, you're telling the job responsibilities are same and the promotion, so I'm confused now. Well, obviously, it could be an internal thing that they call, okay, they recategorize the entire thing and they recategorize in a different manner. If they just recategorize you as a different manner, then the job duties are similar, though. You do not need any amendment just because your title is changed.
Okay. But if job responsibilities are changed a little bit, then?
Is it significant enough, though? It's a little bit. What do you mean little bit? Do you every day you are like a robot? You go click, 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 click. Go back and click, click, click. You do the same thing every day? No, absolutely not. Every day you do a different thing. Every day the challenges are different. Now the question is that, is it a little bit or significant enough? That's a question. Not every single, you do a job on Monday, you do the same, you won't do the job same thing on Tuesday. Absolutely, I know that. You won't click the same button at the same 10:30 a.m. Absolutely not. So obviously job duties vary day to day. There's nothing wrong with it. But if it varies significantly enough, you need an amendment. Who determines that? Is it a significant enough job duty? Most probably you guys can sit down, you and your HR can sit down to see, is it significant difference? According to me though, if you move from Java to SAP, according to me it still is software. I mean, that's up to your HR and you to determine. According to me, it's the same. Now, I know that people may disagree, but that's according to me, it's still the software. Obviously, if you are a software person and then now you are doing a lawyer job, you just got a license as a lawyer. Now you're doing a lawyer job. Absolutely, I believe even if your HR says otherwise, I think so that is a significant change. That's my opinion though. Now it will be up to you and your HR opinion on it.
Got it. So I do have a second question. Like 3 months ago, I moved to new employer. So with my old employer, I had I-140 and my priority date was September 2015.
September 2015, okay. Not.
And I-140 was approved in October 2016. I was with my employer until August 2020.
Okay.
With old employer. In S386 bill, there is a clause like
two years.
Candidates should stay with the employer after I-140 approved like 2 years, right? So with my new employer, when I-140 gets approved, do I need to wait 2 years to file 485?
There are two provisions in the law. One is that the I-140 must have been approved and you must be with the company. for more than 2 years. I slapped you, oops, you fell down. But there is another chance you get. The second chance is your priority date. Remember, you told me your priority date is September 2015. And when I told to Nitya ji, I told her we Indians may get up to 100,000 extra green cards. Guess what? Your priority date should be current. So if you don't get in the first, it's not and, it's or. If your priority date has to be current to file the adjustment of status, or I-140 has been approved for more than 2 years. In your case, you are in the first category itself. You don't have to look into the I-140 category at all.
Okay. So even with the second company, after my I-140 gets approved and when priority date is current, so I can apply for 485.
Right. In your case, though, that will be easily met because I'm expecting the priority to be current for you. If this will pass, I can't say this will pass. It's already passed. It just gets the technical amendments.
Okay.
Yep. Okay.
Thank you, Andy.
Thank you very much.
Thank you so much for calling.
Thank you, Nitya.
Rahul Garu, we have a question on Facebook. This is from Sandeep Kurapati. He says, my cousin is currently on an F1 visa pursuing master's degree. He broke his second semester due to some family reasons and the university stopped online classes for him. Is he supposed to leave the country now or can he wait and restart with the second semester again next year?
No, there are two options. Once the person is out, there are two options. One option is to reinstate them. Normally reinstatement is available if there is some technical problems. Yeah, just hold on for a minute.
Yes, just give us a second. Sorry.
So if the F1 visa, if the F1 visa person gets out of status, there are two provisions. One is that there is something called reinstatement. Normally, if there is a technical error or some health issues, they are going to reinstate. If the family things are there, they are not going to reinstate. The second thing is that he will have to go outside the country and come back in. Assuming his DSO allows it, he can go outside the country and come back in.
Okay. All right, Sandeep, I hope that helped. All right, let's just take our next caller real quick. Sir, please go ahead.
Can you hear me?
Yeah, we can hear you. Please go ahead.
Okay. Thank you, sir, for helping us. My question is related to the 𝗧𝗔𝗟𝗪 benefits. I-140 has been approved with the previous employer and I had been with that employer for more than 2 years after the I-140 has been approved before I moved to the new employer. But my previous employer has withdrawn the I-140 after more than 2 years of approval. So in that case, would I be eligible to file I-485 and I-140 concurrently with the old employer if I go back to them or not?
Unless there is some drastic change in the interpretation of the law by the USCIS, I don't think so that you will be able to file the adjustment of status. The best way for you right now...
They didn't mention clearly.
Right. But they will fill in the gaps. That's the reason we have regulations, interpretations by the USCIS. But based on the way that I can read the USCIS, what I've been, I don't think so that you will be able to file adjustment of status. Hope I'm wrong, but that's the way I'm interpreting right now.
Okay. So actually my priority date is 2013. I just heard the answer from after question. It looks like it will be current.
Absolutely. I'm pretty positive for it. So I want you to jump on the bandwagon, get your company, file your labor certification I-140 soon. And if they don't, well, they don't like you. You just leave the company, go join some other company to get the labor and I-140. Okay?
Okay, sounds good. Okay, thank you, sir. Thank you very much for your help.
Thank you, sir. Thanks for calling in. And at this point in time, we're going to take a short commercial break and we'll be right back to answer more questions. So see you guys soon.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ,
సార్ ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
Mom, what did the man mean when he said go back to where you came from?
Go back, wherever you're from.
Why do they make fun of my name at school?
Kamala.
Dad, who will protect us from climate change?
Global warming, and that a lot of it's a hoax. It's a hoax.
When is Nani coming back from hospital?
Our family's future is at stake. The choice is ours. Vote 𝗬𝗓𝗪 𝗪𝗧𝗛.
I'm a lifelong Republican and I'm pro-business.
I'm a Georgian and I believe in personal responsibility.
I'm a Georgian and I rely on my social security and Medicare.
I am a mother and I believe in immigration policies that support family unity.
My party is not fiscally responsible anymore.
It's irresponsibility that's costing us our lives.
It threatens my social security and Medicare.
It is keeping our families apart.
That's why
I am
voting
𝗬𝗓𝗪
and
𝗪𝗧𝗛.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా. 8,000 మీకే వస్తాయి.
Alright guys, welcome back to our talk show with the expert, Mankuman expert Rahul Reddy garu. Rahul garu, thank you so much. I know we're halfway through. We have a lot of callers, a lot of questions on YouTube and Facebook and Mata. So let's just proceed right away. And while we're taking our next caller, I'm just quickly going to dive into the next question on YouTube. It says, could you please let me know if the date of birth on the birth certificate and passport is different by 2 days? Will that be an issue for adjustment of status or consular processing?
I would recommend that there are some creative ways to resolve these issues rather than actually going and head on, trying to challenge the system when your birth certificate is different and your passport is telling different, your school certificate is telling, your visa, I-94. There are certain ways and creative ways that you can avoid confronting the immigration and telling that the government, Indian government is wrong. They don't care. The Indian government is wrong. They will say you are wrong, and it's very surprising that even though we are in a common law, some of the laws here in United States are interpreted like a civil law system, which we are not in. So they may not be willing to accept it that easily, though.
Okay.
India is completely a common law. Here it's 98% common law. There is a 2% civil law, especially in the marriage and other issues. So I would like to avoid, by contacting a lawyer, there's some creative ways. Maybe not submit the birth certificate. Maybe birth certificate is wrong. Maybe submit the affidavits of birth. Submit the other rest of the documents and avoid that. That should be the best way of doing it. If you try to go on head-on challenging the immigration, saying that the Indian government is wrong, it may go on for like 5 to 10 years for you to resolve it. Will they deny it? I don't think so. They'll deny it. There are other ways of getting it not denied, but they may not be approving it for a long period of time. So to avoid it, I would not submit the birth certificate.
Okay. All right. I hope that helped. Also, on to our next caller. Hello, sir. Our next caller, it says Colin user 1. We don't have an area code. So, sir, if you're on, we're here for you. Hello? Okay, I think let's go to our next caller. And in the meantime, let's take another question on YouTube. This is from Vinod Sudhani. He says, I filed for my adjustment of status. I'm on H1B, and once we received EAD, my wife used the EAD. So then do I also lose the H1B if I still want to maintain that? Also, if my wife uses the advanced parole to enter, will I also lose the H1B status?
If your wife uses an EAD or advanced parole, you do not lose the status. You're still not married to this application. You can still maintain independent. But I don't see a reason why you still want to keep on maintaining the H1B. As I discussed before, I mean, you may want to just try to use the EAD too, just like the wife, and get rid of the H1B. That's, you may want to consider, you may want to discuss with your lawyer, because it is very expensive. I want you to discuss with an independent lawyer though, because a lot of lawyers, some reason, oh, please maintain the H1B. Wow. You know how much cost it is to maintain the H1B? The filing fees right now, they increase the filing fees by, for some of the companies, $4,000. The lawyer's fees, end client letter, vendor letter, then H4, then, and all these things. I'm not sure if you have your I-140 approved, if it's more than 180 days, if I were you, I would turn the H1B like a, you know, like a football thing, and then kick it out, and then I'm happy with the adjustment of status. And that's what I would do. When remember me, when I was in adjustment of status, yeah, we used the EAD, guys. We kicked out the H1B and H4. That's what we did too. But as long as I-140 is approved, I don't see a reason why, you know. But to answer your question, sir, just because your wife uses EAD and advanced parole doesn't mean that your H1B is out. You can still maintain the H1B.
All right. All right, thank you, Rahul Garu. Let's take our next caller. Hello, sir, area code 315.
Can you hear me?
Yes, we can.
Absolutely.
Oh, sir. Yeah.
Yeah. Hi, Rahul Garu. Hi, Mpega Garu. I'm currently on H1, and I moved from company A to company B for my 485, but unfortunately it was not done on time. So I want to move back to company A as soon as possible. So what is the best way I can do? Because
what do you mean it's not? Is your priority date in 2014?
Yeah, 14 December.
Okay, keep going.
Yeah. So I want to move back to company A. So I'm thinking of two options. I don't know whether they are valid. But
wait. Let me understand this. Company A and company B, I got switched up a little bit down. Does the which company has your I-140?
Company B.
So okay.
So you were working company A to B. Recently.
Yeah. You moved from company A to company B recently. So the I-140. So if you want to move to company A, did the company A withdraw the H1B?
No. It's been just 15 days.
So answer to my question is they did not withdraw the H1B.
Correct. That's correct. Yes.
So that's it. Nothing. You don't have to do anything. Just go there. Sir, I'm back. Take me, please. I beg your pardon. I'm back. Wow. The H1B is not withdrawn?
Yeah, actually, they are insisting me to come back. They are insisting me to come back anyway. So I'm ready to go back. The one thing actually, there are two things actually. The company B being a big company, even if I resign there, they'll run my payroll for 1 more week or so. So can I take the resignation date as the last date and come back to company A, or do I need to wait?
Even after you have to stop working, if they run extra money after you leave, that's nothing wrong with it. You did not work, so you're good.
Okay. And one more question is actually, can I, since this is just 15 days, can I disregard these 15 days and ask company A to run my payroll for these 15 days as well? Is that valid? The only thing I'm worried about is I-9.
No, I got the point. What you're telling is that you're only working with company A. You're not working with company B. It is the company B's policy to run the payroll even after you leave for a period of 2 weeks. If they run the payroll, that doesn't mean that you're employed. You have to actually physically work there. You got it? If they pay you just because of their company policy, nothing wrong, take it. You have a problem, give it to Nitya and to me, we'll take it.
Yeah, sure. But one question is actually, since these are 15 days, just 15 days, right? Can I disregard even these 15 days? Just pretend that I didn't join
I have had companies that pay. I have had companies that pay 3 months after they leave the employment. Okay, so so the guy leaves company A, joins company B. Company B, he starts payroll. Company still A still pays him for the next 3 months. Very nice company. I wish I worked for that company. There is absolutely nothing wrong in you taking the 2 payrolls at the same time. There is wrong if you work for 2 companies at the same time, but there is nothing wrong if the previous company's policy is to continue paying. If that's the policy, keep taking the money.
Okay. And actually, my another question is actually, since I joined company B very recently, my company A is ready to continue my payroll even since
I do not like the company A to continue the payroll. They don't need to continue the payroll. But as I said to you, if the company A's policy is to continue when you're not working, nothing wrong. As long as the documentation is clear that you did not work for 2 companies at the same time. Documentation doesn't mean paycheck. You did not went in there. You did not physically work for both the companies at the same time. You did not log in and have the timesheets for both the companies at the same time. I don't have a problem 2 companies paying.
Okay. Even I never filled timesheets for company B, even with 15 days.
You're good, sir. You're good. If you did not work, I trust you. I trust you. I trust you. Okay? Thank you. Thank you very much.
Yeah, thank you. Thank you.
All right, thank you, sir. Thanks for calling in. All right, while we get our next caller, Rahul Garu, question from Vishnuvardhan. Will the lottery be random or wage-wise for the next H1B?
Yeah, that's $1 million question. I was just looking into the ELA before I came in. I thought that this question will come in.
Okay.
The comments period are over right now.
Okay.
So the immigration, this new administration has January 20th. I'm counting every single day. January 20th is almost like 40 days still. Sorry, more than 40 days still left. So this administration can still publish the regulation before they go. It seems very hard because we're already preparing to file the H1B application for the next year. That is starting in March 1st. And now you're telling me that this new regulation is going to come. It may be, I mean, we don't know. There is a chance that it may be based on the wage level. There's a chance for it. And this administration, before they go, they're trying to burn everything they can. And this is one of the other things they want to do right now. And yeah, they may as well do it too. I mean, if they do it, it's going to be very hard for the next administration to undo it. It may take a long time for them to undo it. If they can undo. So if there is any court relief, which seems to be very weak, because most of the court reliefs that we got, Nitya Garu, was because there was no notice period, there was no comment period, they didn't went through the regulation process properly. In this H1B, based on the wage level though, they have gone through the regulatory proceedings as they were supposed to. So we may be very weak. If not, we may not have any position at all in the courts to win. There's a good chance we may not win.
Okay. But Rahul, is there a possibility to overturn this using an executive order or something of that sort?
No.
No?
The reason is that, no. Good question, Nitya Garu. The reason is that, well, they can try. There is something called Constitution. There's something called federal law that's passed by the House and the Senate and signed by the President. Next comes the regulations. Regulations are, they're filling in the gaps, what is left over in the law. And they're filling in, and there is a certain process to fill in the blanks in there. and now we have the executive order. So in the hierarchy, executive order is the least of all the things.
Interesting.
So to overturn the regulation, you need to do another regulation, or probably you need to have a pass a law. If that was the case, where we were not, H4 EAD would have been gone by this time. If the executive order could have undone the regulations. He couldn't do it. Now you may ask, what about the DACA EAD? DACA EAD was not a regulation. It was an executive order by the Trump administration. That's the reason they were able to undo it. Well, courts blocked it. But in this one, if the regulation goes through, though, it's going to be very tough for the new administration to undo it.
Interesting. Wow. Okay. Nice twist in the plot. Yeah. All right. On that note, let's go to our next caller, Rahul V. Hello, sir. Area code 318. We're ready for you.
Yeah. Hello, together. Hi, Rahul V. Thank you for taking my call. Rahul V, the question is, I know I heard many times from you and even over the internet that when the 485 is pending for 180 days, you can move to new employer, right? So
did you say pending up to 180 days or after 180 days?
No, for 180 days, sorry. For 180 days. After 180 days.
Thank you.
We should
There's no for. It's either before or after.
Yeah, after.
Okay. Okay. Second condition is
your
I-140 approved or not approved? Is it filed under downgrade or the regular 485?
No, it's a straight. It's a straight. It's
good. Okay, so let's assume your 485 is pending. Yeah, so your 485 is pending for more than 180 days.
Yeah, that's correct. Yeah, so actually I was offered with my client during the same month when it was current. Then I came to know that I cannot move because I have to file my 485. Good. So the question is, let's say, sorry, go ahead. Yeah.
You go ahead.
Yeah, so the question is, let's say if EAD is not approved by 180 days or after 180 days, is it something to do with EAD, or if it is just pending for 180 days, after 180 days we can move? Because that I could not get the information exactly anyway.
Good question.
Is it
Good question
anything
that you, we didn't answer this in the TVASIA before. If it's pending for more than 180 days, okay? And you don't have an EAD, you can still move to a new company and you can retain the 485 application. But instead of doing one step, you have to do two steps. If the EAD is approved, all you do is 485J supplement, which is very easy, okay? If your EAD is approved. The filing fees for 485J supplement is zero, okay? That's the number one step you need to do. But if the EAD is not approved, not only you have to file the 485J supplement, because you cannot work with this company B because you don't have an employment authorization. So what do? You can file a H-1B application with them.
Okay, so if they sponsor the H-1B, then I can go for H-1B.
Then you can go.
Obviously, I think most likely they will do. Yeah,
most likely, because they were ready to do 2 months ago. They will do 4 months down the line. But one thing is for sure, you need to submit the 485J supplement. Don't be satisfied with the H-1B because two steps you need to do.
Yeah, that I heard from you many times that it has to apply. Yeah, that will make sure. But the only information I could not find anywhere or the internet or from your calls. I've been attending every week your call, but that EAD part I didn't hear from anyone. So I just want to make sure.
No problem.
Yeah. The one follow-up question, Rahul. Sorry. Yeah, one follow-up question on this. Yeah, let's say, if 485 or anything after 180 days, while I am working with a new employer, if there is any RFPs or anything, right, with 485 or 765 or anything, is it something my new employer has to answer or anything to do with the old employer?
If it is to do with the 485, if it is in the 485, it can be answered by the new employer. Absolutely no problem. You're saying that EAD, EAD is something, the only RFP that I see is that when we send the pictures, they somehow, you know how the governments are, they're not only sleepy, they sometimes are, I don't care. They throw the pictures off and then they say, I don't have the passport pictures. That's the only RFEs that I see in the 765 application. In the 485 application, they will give a clear question to us. Are you working with the previous company? If so, submit the 485J supplement. If you're not, then you submit with your new employer 485J supplement. So practically, there is not much to do with your with your previous employer. You're good to go. One thing that I will tell you
so
to
that
do
means
is
we can.
Go ahead.
Yeah. Yes, sir.
Go
ahead. Yeah, so that means we can, when we apply new H1B, we'll apply 765 and everything with the new employer.
No.
Or we don't.
No, you already applied 765. You don't need to. You need to apply 485J supplement.
Okay,
765.
So that means the old 765
old 765 is personal to you. It is not connected with the company. H1B is personal. H1B is to the company. 765 is personal to you. So you don't have to file a 765 again. But you need to do a 485J supplement. Okay?
Okay. Yeah, it's clear. Yeah.
Thank
you so much, Rahul Garu. It's very helpful. Yeah. Thank you. Yeah.
All right, let's take our next caller. But in the meantime, we have a question from Rajan Reddy. He says, I've applied for the adjustment of status last month. If I join another company within 180 days, can I use the EAD advanced parole in the future? Current employer assured that they will continue to support even after leaving the company.
No, I would recommend that this guy does not leave the company within 180 days. He said within 180 days you want to leave?
Yes.
No, don't do that unless the only thing that you love in this world is immigration lawyers. That should not be the way your life should be. No, don't do that. Wait until 180 days before you leave. Because technically, even if your old employer is supporting, but if you are actually working with the old employer, if you leave the old employer, you join a new employer within 180 days, you are committing suicide according to me. I don't know what to say. I mean, your 485 is very life for you. You don't want to do it. So if you're planning to do anything, I strongly advise stick with your company until 180 days.
180 days. So Mr. Rajan Reddy, if you're watching this, there's already enough issues you will face with immigration. So, make it one less by sticking on.
Right. Don't have an immigration lawyer sitting in your home forever.
All right. Thank you on that, Dr. Rahul Garu. Let's take our next caller. Hello, sir. Area code 319. We're ready for you. Hello, sir. Please press *6 to unmute your line. Japan, sir. Hello.
Hello.
Yes, sir.
Yeah.
Hello, Nitya Garu and Rahul Garu.
Hello, sir.
Japan, sir.
Yeah. So I have been attending for your calls every week. So my case was, last time due to my no POM certificate, we applied I-140 for downgrade. My case is EB2, June 2011. So we downgraded. So we applied for downgrade, but we applied only I-140 without any 485 because of no POM certificate. So last, on December 1st, as per even you also suggested in one call to file irrespective of that, we filed a 4IA in requesting a duplicate copy of POM. So that we received a inquiry to submit some identity, to proof of identity. So that is done. So my question is, its processing time is 17 days. That's what we were told. So just in case if I get my POM copy by December 20th or around that time, so what are my options? I have already I-140 applied. So what are my options? Can I go and send that copy to USCIS?
Yeah, you didn't apply the 485 applications, right?
No, I didn't file 485.
Yeah, I think the better
I did not file 485.
I remember having discussion with you. Though, is there any way you can't search in your old emails and find out the job description you had in the previous I-140?
Oh,
in your lawyers and your employers?
We have that details, like, the copy of filed ETA 9098, just a copy
you
of
would then,
file
I mean,
application.
if you have that, I would file a 485. I don't know why you're holding it.
Oh, so we were told that since we don't have a certified ETA 9089 copy, we may be potentially rejected.
You have a chance. I'm not telling you, but I will take the risk of filing the 485. Let it be rejected. That's okay. Because if you miss the boat, you're going to be waiting. You may be waiting. Who knows? So I will take the risk. I will, if I were you are my client, of course it's your money, but I will still risk it filing the 485 application though. Because the backlog in getting the USCIS FOIA information is about 90 days right now, not 17 days. So if I were you, I would file a 485 application and risk myself.
Okay. So assume that if we get any copy by this month also, so
if you get a copy, if you don't get a copy, I'm filing 485 application if I were you. I don't care about $6,000, $7,000 of my money when I come to this stage. I don't know about you, but if you care about $6,000, $7,000 risking, well, I don't know what to say. But if I were you, once I get an EAD, I will take Uber job and work all nights and weekends and finish it up.
So you suggest that I need to file another 485, another I-140.
Well, you didn't file. Did you file another 485? You said you didn't file a 485.
No. I filed only I-140.
You told me that, but you said when you're saying that I have to file another 485. That's the reason I'm asking you. Did you file previously?
Oh, no,
you said no.
Not another 485.
Okay. So if I were you, I would not be trying to save my $5,000. I'll be risking it. That's me, 5 or 7, whatever your lawyer is asking. I'll go for it. Okay?
So you say that we need to go and file another I-140.
I am not telling you. No, just 485.
Okay. So my one more question is, one more question.
But I want to know what kind of person you are. Are you the person who will be concerned about this $6,000, or are you the person who will not be concerned about this $6,000? You'll be risking it. If you're the concern that, I'm going to lose the $6,000, you shouldn't, I'm not a proper lawyer for you.
No, I'm not concerned about the payment. Even my company is also not concerned at all.
I would file the 485 application right now, today. I'll contact you tomorrow. Today's Sunday, not many lawyers work. Contact them tomorrow to file the 485 application.
Sure, definitely.
Okay then.
So my next question is, once we file 485, so can I travel? I have my old parents. Required to visit.
Do you have your
the
passport?
Right time to travel?
The right time to travel is obviously after you get an advance parole. But do you have a passport stamped in your passport right now with H-1B?
No, passport expired, but I got my H-1B renewed just last month. I got 3 years.
Yeah. Are you eligible for the drop box?
I don't know. I didn't try to get that information. No,
I would suggest
my visa got expired even in 2019 Jan.
Okay. So you don't. Did you get your passport stamped in India or Mexico or Canada in previous passport stamped?
Oh, in India.
Okay. Well, you have another problem. January 2019, 2 years of January of 2019 is January of 2021. I would recommend, though, instead of coming to the conference calls and all these things, though, you have a lot of things that you need to discuss. Consult a lawyer. Have it one-on-one. Don't keep on going here and there trying to save the money. It's better because it's just one thing you want to discuss about travel. That looks to be fine. But if you want to discuss about strategy of filing I-140, 485, and all those things, especially when you don't have a labor certification, instead of keeping coming and doing all these things, you may be better off getting the resolution done and probably get an EAD, and I'll work it off by working an extra Uber job to pay off those loans. So that's what I would recommend right now. Okay? Thank you then.
Okay. So, yeah. So
Let's give
what
the
is
chance.
your,
Let's give the chance to other people.
Okay. Thank you, Rahul.
Thank you, sir. Thank you so much
Thank
for
you.
calling. Okay. All right. Okay.
When things are a little bit complex, though, I normally try to have them to direct to a lawyer rather than just resolution in this one.
And it kind of makes sense because there's not just like one question. There's a lot of questions.
Complex of issues.
Yeah, and I think in that case, like
So what is
a lawyer is
let's go to the next question.
Recommended. All right, on to our next caller, sir. Area code 630. We're on for you.
Hello, Rahul Garu.
Cheppan, sir.
Hello, sir. Cheppan.
Can you hear me?
Yes.
Yeah.
I applied my 485. My EB3 date was current, so I applied my 485 with my previous employer. So the situation is, I never worked for that company who sponsored my green card. I never worked for the company. The question is, when I need to join with that company? I heard that we need to work for at least for 6 months for the sponsored company. When I need to join? Before final action date?
You're right. Sorry, I'll take back the word. You're right. If you are not working for the company, though, there is no technical requirement.
Never worked.
Since you never work. There's no technical requirement that you must work for the company. There's no technical requirement. But normally what happens is that the immigration is going to look into the entire history of you. Oh, they filed your labor in 2013. From 2013 to 2020, October, you never worked. In 2020, you worked for, you still did not, after filing an adjustment of status, you did not work. So they will look it down and may consider that you may not have a genuine job opportunity with this company. They may question that one.
Yes.
And that is a big doubt. That's the reason why we strongly recommend people going and working for the company. But is there anything in the law, is there anything in the regulation that absolutely requires that you must work for the company? No.
Yeah, if it is yes, as you said, you are saying yes. So when exactly I need to work? Before my final action date becomes current?
I would suggest you that, it's so hard to get here and you don't want to risk very much at this stage of life. I would recommend it to join right now, at least work 2 to 3 years and make a decision later on what to do.
Okay.
That is my recommendation.
So that's why I'm planning like next.
Yeah, so there is nothing like, there is nothing like,
before.
No, I did not say about final action date. I did not say anything. I'm just telling that any ASAP, if I were you, I would join the company.
Okay.
There is nothing there in the law. It's just the interpretations of the USCIS.
Okay. That's enough. I will try to somehow. Okay, thank you very much.
All right, Andy, have a nice evening. Folks, I think we're all out of time for today, but thank you so much for tuning in. I know we have a lot of questions. There's still a lot of callers waiting for us. But Rahul Garu, we have to come back and address all of these questions next week again. And folks who are watching, thank you so much for tuning into our show today. Please be back same time next week. And Rahul Garu will be here to answer your immigration related questions. So thank you so much and have a great weekend. Rahul Garu, thank you so much for being here again and answering all our questions so patiently.
Thank you very much.
Thanks, Andy.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్గా ఉంటుంది.
పర్ఫెక్ట్గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్. Promise is a promise.
Mom, what did the man mean when he said go back to where you came from?
Go back, wherever you're from.
Why do they make fun of my name at school? Dad, who will protect us from climate change?
Global warming and a lot of it's a hoax. It's a hoax.
When is Mommy coming back from hospital?
Our family's future is at stake. The choice is ours. Vote 𝗬𝗓𝗪 𝗪𝗧𝗛.
I'm a lifelong Republican and I'm pro-business.
I'm a Georgian and I believe in personal responsibility.
I'm a Georgian and I rely on my social security and Medicare.
I am a mother and I believe in immigration policies that support family unity.
My party is not fiscally responsible anymore.
It's irresponsibility that's costing us our lives.
It threatens my social security and Medicare.
It is keeping our families apart.
That's why
I am
I am
voting 𝗬𝗓𝗪
and
𝗪𝗧𝗛.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్.